Hi, my name is Nigel Bowman. I'm a solicitor here at Ison Solicitors. I specialise in family law cases, which means I represent parents and other people involved in disputes about what's best for children of the family, and indeed I represent parents and others in cases where social services are involved with the family. In family law, legal aid covers care proceedings, so if you're involved with a local authority or concerned about your children, then legal aid is generally available for that. Legal aid also covers domestic abuse, so if you're a victim of domestic abuse, legal aid is available. Legal aid also can cover private law proceedings, so if you're in a dispute with your partner about what's best for your children. But in those circumstances, usually you have to prove either that you're a victim of domestic abuse at the hands of the other party, or that your children are at risk of significant harm from the other party. And in those latter two cases, you normally have to show that you are such a victim or the children are at risk by means of some formal document. So that can be quite difficult to prove. I think the best thing to do is to speak to a solicitor who specialises in this area, who can give you advice about that. There is also the legal agency's website, which contains some useful information about whether you qualify or not for legal aid. If you don't qualify for legal aid and you can't afford legal fees, then you can, of course, represent yourself. In fact, that's what you would have to do. However, there are voluntary organisations available who can assist you with that at court. There is the PSU, Personal Support Unit, who can assist you with the drafting of forms, and will sometimes be able to come into court and give you support in front of the judge. It is also possible to take to court with you something called a Mackenzie friend. With the leave of the judge, they can come into court and again give you assistance in presenting your case to the court. The courts are very used to these days people being litigants in person, and so that shouldn't be too much of a difficulty. Generally speaking, legal aid covers all the costs of the proceedings, your legal costs that is, and what we call the disbursements, in other words, the things your solicitor might have to pay for on your behalf, such as interpreter's fees or court fees. The one exception to that can be where you've been assessed as having to pay a contribution to your legal aid, or where you recover or preserve some money or property within the proceedings, in which case the legal agency will ask you to repay your costs from that recovered or preserved property. But of course, that only applies if there is property or money involved in the case. The means test for legal aid, the legal aid agency looks at your financial circumstances, so we'll look at your income and your disposable income, and they will look at your capital, so your savings or any other capital you have, and your income and your capital have to be below a certain limit to qualify for legal aid. That's the means test. The merits test, the legal agency looks at your case and whether it merits legal aid, which in family cases means that it has to be a case where social services are involved to pass the merits test, or you have to be a victim of domestic abuse seeking the protection of the court, or in a private law dispute between parents about what's best for their children. You have to be, again, a victim of domestic abuse and able to prove that, or your children have to be at risk of harm from the other party and able to prove that. If you are the victim of domestic abuse and you want the protection of the court because of that, then you don't need evidence to prove that. You just need to get to see your solicitor and get some advice about it. And if necessary, your solicitor can make an application to court for an order to protect you or your children. If you're wanting legal aid because there's a dispute between you and the other party in the case about what's best for the children, then you need either proof that you were the victim of domestic abuse, which could be a non-molestation order, or that the other party had a conviction, or you would need something from a medical professional confirming you were suffering the effects of domestic abuse. In addition to that, of course, you'll need proof of your financial position, which from the legal aid agency's point of view is normally, as a starting point at least, bank statements and proof of benefiting if you're in receipt of benefit, or wage slips if you are working. Before you see your solicitor about a family case, it's important to have as much information as you can available. Of course, in an emergency, it might be difficult to have all the information that you need, but don't worry about that. But if you can take with you proof of your financial position, and generally speaking for legal aid purposes, that's 3 months bank statements, proof of your income or benefits. And also if you have any documents relating to the case available, that of course would really assist your solicitor if you could take those along as well.